Welcome back. We're going to pick up where we left off with a follow-up question to the previous question we had had. The public defender from Virginia, Michael, indicates that mostly counsel does just disagree with the finding of the court because of defendants' continuing acts that indicate incompetency, including the defendant saying as recently as the competency hearing that he didn't know what he was charged with or how many counts, despite the fact that they had been told that multiple times. And that he also expressed at the competency hearing that he had only heard of his rights to plead guilty or not guilty from co-inmates instead of counsel. The attorney indicates that she does not currently have her own expert on the case.
It would seem to me to be successful in this case, you need your own expert. I guess my question one is, did the state's expert have access to this information that you just shared with me? In terms of not knowing that the defendant said he didn't know what he was being charged with, that he did not know what his plea options were, and did the expert address that in the expert's report? I guess the question is, I don't know because I have no idea who this expert is and whether he or she is a, quote, good expert or not, whether it is worth it to ask for that expert to reevaluate the client in kind of newly discovered evidence, or whether you think that would just be a waste of time and go for your own expert. I think it's very, very important to have access to experts. I filed an amicus brief to the United States Supreme Court back in 1984-85 in Ake versus Oklahoma on the right of a defendant to an expert in an insanity defense case, and that's been on my mind for 30 years, how important independent experts are. And I know that many public defender offices are adverse to providing the funds for them. I think that's very problematic. But here I would say definitely that's the way to go. Okay, so let me go back now to where I was. We've talked about Jackson, we've talked about the implementation of Jackson, but the most important issue into who gets to stand trial eventually and not are the issues of medication. And these are complicated issues, and it is an issue that the U.S. Supreme Court has gone back to on multiple occasions. There are at least 3 cases, only one of which deals with incompetency, but at least 3 criminal procedure cases in which the Supreme Court has dealt with this issue. So this is something that the court is very, very aware of. Before the mid-1980s, the cases were all over the place. And when you read those cases, it was very odd. In each case, it was sort of the judge had no idea that any other judge in any jurisdiction had ever decided a case on this point. No judge ever cited any other cases. And some of the cases found that a defendant could be medicated as much as the state wanted him to. Other courts found that the defendant was so over-medicated that it, quote, zombified him and made him less competent than he was before. In other words, before the mid-1980s, this state of law was in a total disarray. In 1987, the Supreme Court decides a case, the Fourth Circuit panel from Virginia decides, North Carolina, it was Butner, decides a case called United States versus Charters. Charters wrote a threatening letter to President Reagan, and this coming only a few years after John Hinckley shot Reagan. The government was on very, very heightened alert about any potential presidential threat. Charters was sent to Butner. Charters wanted to refuse his medication. Charters represents himself pro se in the district court in North Carolina, which is pretty amazing. The case goes to the Fourth Circuit, and the Fourth Circuit finds very, very broad rights for a currently incompetent stand trial defendant to refuse medication, based on the right to privacy, based on the right of freedom of thought, and based on the right to freedom from unwanted physical intrusion. The case then goes from the Fourth Circuit panel to the en banc, Fourth Circuit, all the judges together, and they vacate. They sharply curtail the rights that the district court had found, and they relied on the, quote, substantial professional judgment standard that the U.S. Supreme Court had established in 1982 in Youngberg versus Romeo, very, very close to the professional judgment standard that the Supreme Court adopted in Strickland versus Washington, the adequacy of counsel case in 1983. After Charters 2 was decided, basically there was no more activity in federal courts for quite a while in this area because charters was wasn't the controlling law, but it was certainly the law. And as long as there was substantial professional judgment, if the state hospital, federal hospital doctor said, well, it's my judgment, then it was a loser. But then in the mid-late 90s, a few circuits started moving away from it and saying that there were, that there are some fundamental issues here involved in the right to refuse medication. Those of you who know how the civil right to refuse medication cases have developed know that in many jurisdictions these rights were very, very broad. And in the 90s, several circuits said, wait a minute, we're not going to go along with charters. At the same time, the United States Supreme Court had decided two cases. A case called Washington versus Harper in 1990 that said there were very limited rights for a prisoner to refuse medication because administrative needs trumped his civil liberties. But then, a couple of years later, in a case called Riggins versus Nevada, Riggins was a competent defendant pleading insanity, and his right to refuse medication was upheld because the court said, basically a Sixth Amendment decision, he could not adequately consult with counsel if he was being medicated against his will. Riggins was given, I think, 800 milligrams of Mellaril, which the expert said was enough to tranquilize an elephant, just to give you an idea of what was going on there. So the Supreme Court made clear that Riggins, unlike Harper, had not been convicted. So he stood before the court as an innocent person, as, of course, does any person who is currently incompetent to stand trial. So Sell versus United States in 2003 resolves these issues. What are the facts of Sell? They are like no other case. Sell was a dentist who was charged with several counts of mail fraud, Medicaid fraud, money laundering because he submitted fictitious insurance claims to the government. He's later indicted for attempting to murder the FBI agent who had arrested him and a former employee who planned to testify against him in the fraud case. He is found incompetent to stand trial, and he is ordered hospitalized for up to 4 months to determine whether there was a, quote, substantial probability that he would attain competency. So the trial court in Missouri and Sell was doing exactly what Jackson said he had to do. 2 months into this hospitalization, the hospital recommends he get antipsychotic medication, and he refuses. There are administrative proceedings, and he gets a hearing after that, and the magistrate says no, he's a danger to himself and others. The government found that the only thing that could make Sell competent to stand trial was these antipsychotic medications. That's the magistrate. The district court said his finding of Sell's dangerousness was erroneous, but it still affirms the order, saying medicating Sell is the only viable hope, kind of a last clear chance doctrine of rendering him competent to stand trial. And the Eighth Circuit affirms. Case goes to the U.S. Supreme Court, which vacates the Eighth Circuit's judgment. And the Supreme Court holds that the federal government may involuntarily administer medication, antipsychotic medication, to render a mentally ill defendant competent to stand trial only if, 1, the treatment is medically appropriate, 2, it is substantially, and it's interesting, the Supreme Court, in its opinion, underscored substantially. The Supreme Court rarely uses italics, and it used them several times here. Substantially unlikely to have side effects that might undermine the trial's fairness, and that it was necessary to significantly, also underscored, further important governmental-related trial interests. And the court reasons here, under Harper, that's the first case I mentioned to you before, prisoner's right to refuse, and under Riggins, the more expansive, slightly later case of insanity defendants, that Sell had a liberty interest protected by the Due Process Clause, Fifth Amendment here because it was federal, but it would be 14th Amendment in state cases, against all but essential or overriding state interests in avoiding involuntary administration of antipsychotic drugs. Interesting point. In Riggins, Justice Kennedy concurred, saying the majority didn't go far enough. I would hold, given the possible damage that these drugs can do in terms of the side effect, I would find it is virtually impossible for the state to show a compelling state interest to drug somebody over their objection. The cell case, to some extent, seems quite comfortable with Justice Kennedy's concurrence. And the court looks at these issues separately. Well, the court has to find, the trial court, that there must be important governmental interests at stake. Bringing an individual to trial who is accused of a serious crime is important. Of course, there have been multiple cases on what's serious, what's not serious. Court's going every which way. Secondly, the court has to conclude that involuntary medication will significantly further state interests and must find it is substantially likely to render him competent to stand trial. At the same time, the court warned that the trial court has to find that these drugs are unlikely to have, substantially unlikely, underscored, to have side effects that will adhere significantly with the defendant's ability to assist counsel in conducting his defense, thereby rendering the trial unfair. So Perlin rule on all of this is, the Supreme Court is much more interested in side effects as they affect the fairness of the trial than other courts are in looking at medication side effects in civil cases on what kind of ultimate impact, neurological and physiological impact, does it have on the civil plaintiff. The court here is looking at a question of fair trial. And then finally, the court says that the medication is necessary to further these interests, and that any alternative, less intrusive treatments are unlikely to achieve substantially the same results. And when I read this the first time, I read underscored less intrusive, because here we've got the Supreme Court basically embracing least restrictive alternative, least intrusive in treatment, major buzzword in all of mental disability law since the early 1970s. The court is saying we are applying that methodology to cases involving criminal defendants. And that got a big wow and a big exclamation point from me on the side of the slip opinion. And the court says they have to be medically appropriate in the patient's best medical interest in light of his medical condition. There have been many, 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 many post-cell cases, and I will say that by and large, most courts have looked at cell issues relatively thoughtfully. Not all, of course, but I think that courts have taken cell far more seriously than they have taken many of the other Supreme Court cases that found for criminal defendants. If you have cases in your practice with medication issues, I urge you to read the post-cell cases and see which one of these may apply to your situation. Again, as I said before in my treatise, I deal with all of these cases, and there's hundreds. I mean, I don't write about all of them, but I mention most of them. And I write about the ones in which the courts very seriously take seriously, well, what was the least restrictive alternative? If he wasn't going to get this drug, what else would you have done? In some cases, the hospital had no answer. There are some cases in which the court just kind of like blew it off, substantial judgment, and let it go with that. But I believe that cell issues are on the table in any case in which you're representing a defendant who is incompetent to stand trial and the state is seeking to involuntarily medicate him to make him competent to stand trial. Again, the court is looking mostly at the extent to which the side effects might impair his ability to consult with you, but I would go further and talk about how the side effects might damage him. It depends what drug he's getting. Everybody reacts to drugs in different ways. We know that. But there's all sorts of literature. There's all sorts of case law, civil cases involving the kinds of permanent disabling physiological, neurological disabilities that are often follow the improper medication. There is a disease called tardive dyskinesia. And if you go back and you look at cases like Mills v. Rogers, Rennie v. Klein, the major late 70s, early 80s civil cases, you will see the courts talk about these side effects and how debilitating they are. Look at those cases and add that to your briefs as well. There are a couple, I mean, there's lots, obviously, that I did not put in my PowerPoints. I just want to make a couple, before I go on to the restoration issue, just want to make a couple of points. And I probably should have added these to the PowerPoints. What about the question of bail? The denial or revocation of bail during the time of a competency evaluation is almost always common practice in many states. But these evaluations, in many situations, can be done as an outpatient basis. I believe denial of bail should not be automatic. Most jurisdictions where I've talked to people, they said, this is something new because the bail was never raised. It just was always denied. My feeling is the more that you raise the bail issue, eventually you will be successful. Again, think about what I was talking about the ADA earlier, and think about unnecessary isolation, segregation. By refusing bail to someone on the kind of a criminal charge that bail would ordinarily be available for, simply because he is mentally ill, I think raises real questions under the ADA.
Michael, that actually ties in very well with a question that we just received.
Terrific.
A public defender in Washington State asks, in my jurisdiction, we often request evaluations, but find that our clients are held for months at a time just waiting for an evaluation. Many clients end up spending more time in a hospital or jail waiting for an evaluation when compared to the sentence that they would have likely received for the charge at issue. Can this be challenged under Jackson, or is there another remedy? Defense attorneys in my jurisdiction may be reluctant to request an evaluation based on incompetency to stand trial due to the fact that their client could end up sitting for months in a hospital or jail waiting for an evaluation.
There used to be a TV quiz show, I don't remember what it was, in which at one point the host would say, let's turn over all the cards and give the prize to whoever it was. What was that show? You remember? No, you wouldn't. I was asking Norman. Yeah, he remembers. You've asked the right question. You've asked the best question that could be asked. What do you do? And I've actually, sorry? What's my line? You've got it. Thank you. Sorry for this little intrusion. Those of us who remember TV shows from the 1950s and 60s like to talk about them. This is the most important question. I once did a debate at the Association of American Law Schools with Professor Kerry Gould. Did you know Kerry? About this, in which she took the point that you should not automatically raise the incompetency status because of exactly what you just said. I, playing part of the debate, said, no, you have to because you have the bona fide doubt underpaid. And we debated, and there was great interest in it. I believe Kerry was, I mean, the position that Kerry took, we both agreed, was absolutely right. Because if your client is going to be consigned, I don't want to be trite here and cite, the line in Hotel California, you can check it any time you like, you can never leave, but that's the right line for this. That's not a good thing to do. There seem to me to be several options. One, you're in Washington, good. You have a great disability rights office there. David Carlson is the head of it. I don't know if you know David, he's in Seattle. Call him up. Talk to him about the situation you have. Because I think a civil suit against the forensic facility saying that this is basically unfair for precisely the reasons that Diane just read me from your question, that this violates due process and is in fact a collateral violation of Jackson, I believe David's office would be interested in taking that case. And I believe besides your client, there are many, many more. I'm going to get very personal now. My son is a public defender in Brooklyn. And I was talking to him the other day about a case of his. And he said, the judge wanted to order a 7:30 and I opposed it. A 7:30 is in competency and trial. I said, Alex, I'm curious, why did you oppose it? Oh, Alex, if you're watching this, I hope you don't mind I'm using your name. And he said because he would have gone, the time of evaluation at Kirby would have been far more than the exposure he had for the charge he had in front of him. I said, you did exactly the right thing. This is a serious issue. But there has to be a culture developed around this because the gut reaction of public defenders traditionally has been sending him for an evaluation is a win. And it may not be a win. And I'm thrilled you asked me this question. So I think, yeah, if you could talk to Disability Rights of Washington, think about structuring litigation. And what's your remedy? your remedy is that the state has to do evaluations of people who are charged with lesser potential ceiling sentence levels in a more expeditious manner. Or maybe we'll do them outside of the hospital, as I just said when I was talking about bail. Many of these can be done in the community, and why not this? There's a knee-jerk reaction to do them all in the maximum security facility. They don't need to be. If your guy's charged with 5 homicides, different story. But then again, he wouldn't. That goes against the rest of what you said. So I don't think that's so, because he wouldn't be getting out soon anyway. Those would be my 2 options. And ask Diane another question if you have any follow-up on that. But I think that would work. Okay. There's a whole other range, and again, this is not in the PowerPoints, of issues that I did not discuss. And I'm just going to read you some of them, laundry list them, just to give you a sense of how utterly open-ended the whole incompetency process might be. Does the defendant have a right to be present at his incompetency hearing? Remarkably, there's at least one case, a Louisiana case from '99, that said his absence did not warrant reversal of the hearing. I think that's bizarre. Does the media have a right to competency reports prepared in criminal cases? What's the right of an incompetent defendant to testify before a grand jury? What's the right of a defendant to testify or to refuse to testify at a competency hearing? What about if a defendant wants to move to change venue for an incompetency proceeding? Does the defendant have a right to have his attorney testify as to the extent to which he has an ability to aid in his defense? To what extent, in some cases, these are jury, I never did this before a jury. In my jurisdiction, it was always done by the court. In some jurisdictions, Texas, California, juries hear them. To what extent can a trial jury consider statutory alternatives for treatment and custody of incompetent defendants? In other words, does the jury have a right to know whether or not the person is just going to go on the street or be treated somewhere else? And both Texas and California said there was no such right. What's the relationship between filing an incompetency motion and speedy trial periods? Generally, speedy trial is told. On and on and on. The point is, and again, this is all in Chapter 8 of my treatise, but what you need to know is there are so many issues and sub-issues and sub-issues. You should never think that this is a cut and dried matter. Okay, so besides drugs, what else do we do? Well, there's different kinds of restoration processes. And the Western District of Louisiana in 2000, in a case called United States versus Duhan, described one of the programs and said, the report that was offered no explanation as to what information was presented. What did Duhan actually understand, and what did he memorize in role responses? I want to tell you about an experience I had in a state facility in the Southwest Midwest, around 2000, I think. A few things shock me anymore, but I have to tell you, this absolutely blew me away in a very negative way. In the state hospital, forensic hospital, there was a classroom, and it looked like a 2nd or 3rd grade classroom. I mean, it was just what it was. And there were seats for the defendants to sit in. And there was someone in the front of the room. And he would call out in call and response way, who's the person who sits in front of the room? The judge. Who's the person who sits next to you? My lawyer. Who's the person that sits at the other table? The prosecutor. Who are the 12 people sitting over on the side? The jury. What's the jury going to do? Decide if I'm guilty. Competent to stand trial. Over and over and over again. It was one of the most numbing experiences of my life. There's now some, and researchers have started to look at that and said, many of these people, they're in a cycle. They'll come in, they'll be found competent, they'll sit in the jail, they will deteriorate because they were never really treated, and they go back. Just this whole kind of unending loop. Recent research, and I've seen this presented at the American Academy of Psychiatry and Law and some other places, says what's missing from most restoration programs is the irrational thinking abilities that allow a defendant to effectively assist counsel. What I just described to you has nothing at all to do with rational thinking. And I think that some of this research, again, it's available, should be used, should be employed if you are in one of those jurisdictions. Louisiana, Oklahoma, there are others that uses these restoration programs. And I say restoration, sick, because it is really not restoration. Okay, so what are some of the issues to think about? Well, think about and I should have mentioned this with Dropey, I'm glad I'm mentioning it now. The inquiry into incompetency to stand trial is not a one and done inquiry. In other words, he's incompetent, he's competent, the day starts, and that's the end of it. Dropey makes it very clear that the Dusky standard must be reconsidered all along the course of the trial. If there is an issue in the middle, the judge cannot say, oh, I've already decided that. I've written extensively about the Colin Ferguson case. Colin Ferguson was a guy who 20 years ago killed many and wounded others on a commuter train in Long Island. I thought his competence at trial was utterly marginal, but by the time the trial got underway, he had completely lost it. Judge never questioned it. That's wrong. So that's kind of number one. The due process clause is always implicated in any kind of a decision involving competency to stand trial. Medication is still, the whole question of medication, it's the most important legal issue, and you can't ever get away from that. Yes?
Michael, keeping in mind that competency is something that can be reevaluated several times throughout a proceeding, we did get a question from an attorney asking who had a client who was previously found incompetent to stand trial in 2014, and the state has now decided that it wants to evaluate the client, and the attorney would like to know if the state is able to bring that back up for a client who has been found incompetent. Is the state allowed to now reevaluate that?
Wait, was he found incompetent or competent?
Incompetent.
And he's now in the forensic hospital, and the state wants to have him reevaluated for competency?
I am not sure of the client's current status.
I would think the state, if the defendant is incompetent, I mean, there's a whole lot of other questions I need to know the answer to. Is he being treated? Is he making progress towards competency? I would really need to know that before answering it. I know if it's the other way around, if the case is going on and the DA thinks this guy is not competent, under Dropey, the DA is obligated to raise the issue. Rarely does it, but is obligated to raise the issue. But this other question, I would need to know a little bit more, so maybe the person can give it. Okay, what are some other issues? Well, as I said already, the failure to implement Jackson v. Indiana universally is very serious. There are many problems with forensic testimony in many jurisdictions. It is simply inadequate. Courts don't understand standards in many places. Soon after, I think it was Jackson, the National Center for State Courts, which used to do a lot of work in this area, I don't know if they still do or not, I don't think so, did a survey of judges, and a significant amount of judges answered the question, a defendant who is incompetent to stand trial could become competent if he really tried to. This notion that people can kind of lift themselves up from their bootstraps and make themselves competent is utterly, utterly without merit. But it's something that we need to think about, that trial judges feel that way. So, what are the policy issues to always keep in mind, posted on your forehead? One, the fact that courts are mesmerized by the notion of fear of faking, that expert witnesses can be, quote, duped easily. They cannot. And there is so much valid and reliable research that cuts against this. I've written about it a lot, and so have many other people. I don't do my own research. I just, write what other people talk about. But it's all out there, the best research in the world on this. Number two, for my treatise, every year I do an update. I do a pocket part, a supplement. And no year has gone by since I started this in 1989 in which there have not been cases in which appellate courts have vacated trial judge decisions because the judge misapplied an incompetency status in an insanity case or vice versa. There are different standards. There's different points on the timeline. We know that. Incompetency is today. Insanity is when the case was heard. Judges mess this up all the time. You need to know that. The relationship between incompetency and subsequent commitment in many jurisdictions, as I have said, that once a person is found incompetent, he goes to the maximum security facility no matter what he or she is charged with. That is inappropriate. You need to think about that. And you have to consider about the connection between that institutionalization and whether a person is actually being treated in that facility. All too often, utterly inadequate testimony is accepted, and I think that's an issue that we need to think about clearly as well. Okay, and with that, we finish the first part of the presentation. If you want to kind of symbolically stretch for about 10 seconds, we can, and we're going to move on to part two. Again, if there are any other questions on part one now, let Diane know before I start part two. It would be a very good time.
Michael, a follow-up to the question that we just had. The attorney responds that the client is out on bail and is not currently being treated, and there do not appear to be any changed circumstances leading to the state asking for this additional evaluation.
I would then ask, my question would be, why does the state want this evaluation? What is the state offered to the court as to require this evaluation? What evidence is there? Is there expert evidence? Very often, this is something I'm not talking about much today. I spoke about this in March at the American College of Forensic Psychology. You'll go to the jail, and the jail guard will say, hey, this guy's not crazy. I've known him since high school. He's just faking. Or the other way around, say, boy, you got to do something, but this guy's out of his mind. You really have to think about lay testimony. Of course, the jail guard may have, his own fish to fry in this, but I think it's not a bad thing to listen to what other people say, but to be very, very careful, as to what their ulterior motives might be. But here I would want to know more.
Michael, we also have a question from a public defender asking, what are the ethical considerations of not requesting an evaluation for a client you have good reason to believe is incompetent? Can you orchestrate a plea of guilty for your likely incompetent client because it would result in less time in custody?
That's a very hard question. And the ethics, I don't think there's any ethics opinions by state bar associations. They don't care about this. But the professors who write about law and ethics kind of come out on both sides of this. And my sense is, how incompetent is he? If he says to you, I'm Napoleon, and Napoleon can plead guilty to anything because the Holy Roman Empire lets him know, I don't plead him guilty. But that's very rare. There are very, very few cases with that kind of a defendant. If it's on the border and you think you can explain to your client and not just force feed him and not badger him and not hit him over the head with this, but engage in a conversation with him and say, look, you're pleading guilty, and once you plead guilty, also, if someone has a criminal record, doesn't have a criminal record, that's different. Oh, if somebody may not be a citizen, there's all sorts of Padilla versus Kentucky issues. That's not what I'm talking about today, but they've got to be on your mind at all time that you need to talk about. But let's assume there's no Padilla issue. Let's assume the guy has some record. So pleading guilty to this charge is not going to mean he's now going to be ineligible for doing X, Y, Z. Find out if he says, yeah, I did it. Yeah, and if you get an explanation that satisfies you, that he may have, there might be some problems at trial, so he might be incompetent, but that he knows why he is pleading guilty, then I'm comfortable with it. Interestingly, I'm going to be talking about guilty pleas right now in the context of the case of Godinez versus Moran. So maybe hold off on this a little bit until I finish with Godinez. Okay, thank you. Okay, so what do we have here? So we've now moved on to the second part of what I'm going to be talking about, which is guilty pleas and waiver of counsel. And I'm going to set this up a little bit before we talk about Godinez. What was the status of the law before Godinez? Courts agreed, in general, that the standard for competence to plead guilty was higher than for other forms of waiver. But the question was, is this standard higher than or the same as the standard for competence to stand trial? Before Godinez, courts were split on this question. The majority said the standard was identical. The question was, did the defendant have sufficient present ability to consult with his lawyer with a reasonable degree of understanding, whether he had a rational as well as a factual understanding of the proceedings against him? In other words, verbatim, the Dusky standard. However, there was a minority of cases. They said, no, you need a more searching standard in assessing pleading of guilty than you do for standing trial. A defendant is not competent to plead guilty if the disability, and here again I'm talking now to the lawyer who just asked me the question, has substantially, even though this is no longer the law, I think it's something you should think about, has the disability substantially impaired his ability to make a reasoned choice among the alternatives presented and to understand the consequences of the plea. In other words, well, if you go to trial, you might be acquitted, but if you're convicted, you might get 15 years. Under the terms of this plea bargain, you'll get 6 months. Do you get that? And the test is that test that I just told you has been employed by courts that found it necessary for judges to assess a defendant's competency, underscore this while you're listening to it, with specific reference to the gravity of the decisions with which the defendant is faced. In other words, a simple finding of trial competency may not be a sufficient basis for finding that defendants could make other decisions, quote, of very serious import. Now, what's really interesting to me, and I had been writing about this and thinking about this and doing this for many years before I figured this out, the vast majority of cases that adhere to this minority position involve defendants with intellectual disabilities, not with mental illness. That's never before the U.S. That issue has never been before the U.S. Supreme Court. But if you look at the pre-Godinez cases and put them into two categories, put them on two sides of the table, you will see that the ones that the minority jurisdiction that say you have to have a more searching inquiry, by and large, involve defendants with intellectual disabilities. The notion of a, quote, reasoned choice is extremely, extremely important to all of this. Now, I've already told you about all of this, so we can keep going on. Okay. Oh, you know, I certainly did. You will forgive me. I'm sorry. Thank you. Diane keeps me more or less honest here. Okay, as I was having trouble seeing it, I'm sorry. We're up through here. Okay, so let's talk about, we're right up to where we should be. Let's talk about Godinez. What's it about? Moran is a defendant. He shoots and kills the bartender and a patron of a Las Vegas bar. 9 days later, he appears at his ex-wife's apartment. He shoots her 5 times, and he tries to commit suicide. While he is in the hospital, he confesses to all 3 killings. He's charged with 3 counts of first-degree murder. He pleads not guilty. The prosecutor says, I'm going to seek the death penalty. And he asks to discharge his attorney and change his plea to guilty. The court accepts his waiver, changes his plea to guilty, and he's sentenced to death for all 3 murders. The Ninth Circuit reverses, finding that competency to waive constitutional rights requires a higher level of mental functioning than that required to stand trial. In other words, the Ninth Circuit aligned itself with the minority holding of the pre-Godinez cases. The Supreme Court reverses, per Justice Thomas, and says the standard for pleading guilty is no higher than for standing trial. In fact, it is identical to the Dusky standard. So if this was high school math, our equal sign would have 3 horizontal bars. There is a dissent by Justice Blackmun, which focuses squarely on the likely potential that Moran's decision to plead guilty was the product of medication and mental illness. And in terms of the medication, Blackman in his dissent notes that Moran was receiving 4 medications at the time of his plea, and he quotes the trial transcript to show that many of his responses were monosyllabic, like that. It's hard to tell with a court reporter, and that it was very, very unclear that he understood. The most important, I told you my favorite sentence in everything was the QBID that Blackman gave in Jackson. Well, here's my favorite analogy. The majority cannot isolate the term competent and apply it in a vacuum, divorced from the specific context. Here it comes. A person who is competent to play basketball is not thereby competent to play the violin. I can't tell you how many times I have quoted that over the years, because I think that's the best sentence that's ever been written. The majority's monolithic approach to competency is true to neither life nor the law. Competency for one purpose does not necessarily translate to competency for another purpose. I want you to keep this in mind. Just put this in memory until I talk about Indiana versus Edwards in about 5 or 10 minutes, and see the extent to which the Edwards court, without ever saying it, is now endorsing this position of Justice Blackmun's in Godinez. That's holding number 1 of Godinez. What's the other holding? The question is whether or not he can waive counsel. Well, there was some Supreme Court law on waiver of counsel having nothing to do with mental disability prior to Godinez, almost 20 years before, in a case called Ferretta versus California. And Ferretta says the defendant had a federal constitutional right to represent himself if he voluntarily elects to do so, if he had the mental capacity to waive the right with a realization of the probable risks and consequences. It's not necessary the defendant is technically competent to represent himself, but only that he is free of mental disorder that would so impair his free will so that the waiver decision would not be voluntary. In Ferretta, the trial judge asked Ferretta questions, it was in California, about California jury selection, about peremptory challenges, about of course challenges. It asked questions about evidence law. What are the hearsay exceptions? Right, sound like a law school evidence teacher, right? And of course Ferretta did not know those. And the court in Ferretta said, that's not the point. He does not have to be competent to represent himself. He has to be competent to make the decision to want to represent himself. Now, before Godinez, looking at cases involving defendants with mental disabilities, the court said, just because somebody acted bizarrely, spoke bizarrely, acted eccentrically, or had once been diagnosed as having paranoid schizophrenia, that's not enough in some cases to establish a lack of capacity to represent yourself. But on the other hand, the courts all said you have to scrutinize counsel waivers very, very carefully, and the record has to reflect that the defendant was offered counsel and he knowingly and he intelligently refused it. And again, go back to the, I guess, 1938 case of Johnston versus Zerbst about waiver being knowing and intelligent and voluntary. That's really what the pre-Godinez cases all said. And some courts found that the standard for self-representation was higher than for competency to stand trial because literacy and a basic understanding over and above the competence to stand trial may be required. And I put on the board here a 1980 Wisconsin case called Pickens versus State that's still the lead case in this area from before Godinez. Surely a defendant who, while mentally competent to be tried, is simply incapable of effective communication or because of less than average intellectual powers is unable to attain the minimal understanding necessary to present a defense is not to be allowed to, quote, go to jail under his own banner. And that's a great quote, I think, to use. So what does Godinez have to say about this? Godinez says, wrong. The standard is exactly the same. A defendant who is found competent to stand trial has to make many decisions, whether to testify, whether to seek a jury trial, whether to cross-examine, whether to raise an affirmative defense. The court says, while the decision to plead guilty is a profound one, it is no more complicated than all the decisions put together that a defendant may be called upon to make during the course of a trial. A defendant, court says, who waives his constitutional right, it has to be knowing, it has to be voluntary. Requiring that a criminal defendant be competent has a modest aim. It seeks to ensure he has the capacity to understand the proceedings and assist counsel. While psychiatrists and scholars may find it useful to classify the various kinds and degrees of competence, while states are free to adopt more elaborate standards, the Due Process Clause does not impose these additional requirements. Kind of this sort of a hostile, negative tone creeps out to me in that line about psychiatrists and scholars. Like, well, what do they know, right? In fact, there's a connection, and I just thought about this morning for the first time, between this opinion and something I'm not going to be talking about today, the Supreme Court's most recent death penalty decision involving defendants with intellectual disabilities, Hall versus Florida, in which, in his dissent, Justice Alito whines about the fact that the Supreme Court is looking at the elites, the professional associations, in coming to its decision. I mean, it's an incredibly anti-intellectual decision. Here it's the same thing. Well, psychiatrists may think that, other lawyers may think that, but that's not really very important at all. The court says there is no reason to believe that the decision to waive counsel requires an appreciably higher level of mental functioning than the decision to waive any other constitutional right. And the court rejected defendants' other arguments that a self-representing defendant must have greater powers of comprehension, judgment, and reason than would be necessary to stand trial with the aid of an attorney. Defendant's argument, the court says, rests on a flawed premise that competence, it says, the competence that is required is the competence to waive the right, not the competence to represent himself. So the only question the Supreme Court is interested in Godinez is he competent to waive it? And the court says if he's able, his ability to represent himself, see Ferretta, has no bearing on his competence to choose self-representation. Now, besides the dissent by Justice Blackmun that I mentioned before, and I will mention again, there is also, I think, a very important concurrence by Kennedy and Scalia. And they're concerned, they said they have serious doubts about whether or not there should be a heightened competency standard if these decisions made by a defendant pleading guilty and made by a defendant who stands trial were not equivalent. What's most important in their concurrence is it limits, they believe, the majority never says this, but the majority also doesn't go out of its way in a footnote to say they're wrong, which the majority does very, very often. The court says this is limited, this decision is limited to decisions that occur, quote, during the criminal proceedings. Well, that's a great question. What does that mean? When does the proceeding start? When does it end? Is it everything from the time the guy is indicted to the time he has exhausted his last appeal? Or is it only from the time the judge bangs the gavel down and says, please rise, and the trial is being held? This comes up later in other cases. I think it's very, very important that we think about that. There is a dissent by Justice Blackmun. He dissents on everything and on this point. A finding the defendant is competent to stand trial just says he's capable of aiding his attorney in making the critical decisions required at trial. Look at everything I've talked about when I was talking about competency to stand trial. Can you aid your lawyer? Can you do it rationally? The reliability or even relevance of such a finding vanishes when its basic premise, the counsel is there, ceases to exist. The question is no longer whether the defendant can proceed with an attorney, but can he proceed alone and uncounseled? That's Justice Blackmun's position on this. And that's really where Godinez says. So, this is 1993. The Supreme Court comes back to this 15 years later in Indiana versus Edwards. And it's really, of all the cases that I've talked about today, it's the only time, I think, that the Supreme Court has ever questioned itself and said, maybe we screwed up the first time around. It never really says that, of course, but that's what it means. So here's the issue. Edwards is charged with attempted murder, with battery with a deadly weapon, criminal recklessness and theft, all emanating from, this is so banal, from his attempts to steal a pair of shoes from an Indiana department store. I mean, I shake my head, and again, I've been doing this work for 40 years. How many of the biggest and most serious cases flow from what are down at the base such minor crimes? I'm sorry. There are many competency hearings. A testifying psychiatrist reports Edwards did understand the charges, but he could not cooperate with his lawyer because of his schizophrenia. He had delusions, he couldn't think, and he couldn't cooperate. He knew what he was being charged with, but he wasn't able to help his lawyer. And the court said he was not competent to stand trial, and he was ordered recommitted. 8 months later, just before trial, he asked to represent himself. The court refuses. He goes to trial represented by counsel. He's convicted of criminal recklessness and theft, but the jury does not reach a verdict on attempted murder and battery. The state says, we are going to retry you, because after the jury's hung, he again asks the court to represent himself. Referring to the lengthy record of psychiatric evaluations, the court says Edwards still suffers from schizophrenia and says, with these findings, he's competent to stand trial, but I'm not going to find he's competent to defend himself. So the trial judge in Edwards splits the difference here and says he may be competent to go to trial, he is not competent to waive counsel. He's represented by appointed counsel at retrial, he's convicted by a jury on both counts. Indiana's Intermediate Appellate Court orders a new trial. The Supreme Court finds that both Ferretta and Godinez, the Indiana Supreme Court, required the state to allow him to represent himself. So what happens at the Supreme Court? The Supreme Court distinguishes Godinez on the grounds that case, Moran's case in Godinez, involved a guilty plea. The only question to be considered was a defendant's ability to waive the right, as compared to the case before it that sought to measure the defendant's ability to conduct trial proceedings. The question, did the Constitution permit a state to limit the defendant's self-representation right by insisting on representation at trial on the grounds that the defendant lacked the mental capacity to conduct his trial defense unless represented? And the Supreme Court says yes. The Supreme Court says that Dropey and Dusky, the competency cases, set out a standard that focuses on his present ability to consult with his counsel, his capacity, and help counsel prepare his defense. And the court says, in direct opposition to what Thomas said in Godinez about there's only a unitary standard, the court says we caution against the use of a single competency standard, for deciding, one, whether a defendant who is represented by counsel can proceed to trial, and two, whether a defendant who goes to trial must be permitted to represent himself. Some of you may know about procedural justice. It's a very important concept. I recommend you read about it. Tom Tyler, who's a professor at NYU now, is the first person who ever really wrote about it in depth, and basically says it's not always so important whether we win or lose, but it's important whether or not we're treated fairly. And the court says from a procedural justice perspective, Edwards is not being treated fairly. Mental illness is not a unitary concept, and that in and of itself, that one line, is extraordinarily important because courts so often want dyadic. Is he, quote, crazy or is he not? Well, the court in Edwards says it's not that easy of a question. It varies in degree. It varies over time. It interferes with an individual's functioning in different times in different ways. This case shows how complex it is. In some instances, an individual may well be able to satisfy Dusky's mental competence standard because he can work with counsel at trial, yet be unable to carry out the basic tasks needed to present his own defense without the help of counsel. It also looked at dignitarian concerns. And the word dignity, and something I'm very, very interested in a whole lot of context, is being used by courts more and more. But it's the first time that I believe it's been used by the U.S. Supreme Court in a case involving a defendant with a mental disability. Dignity and autonomy of the individual, the court says, underlie the self-representation right and underscore that in a case with a defendant with an uncertain mental state, the spectacle that could well result from his self-representation at trial is at least as likely to prove humiliating as ennobling. And I think this is fantastic language for a criminal trial lawyer to glom onto and use. Not only must proceedings be fair, they must appear to be fair. And a psychiatrist who observes the defendant says, how in the world can our legal system allow an insane man to defend himself? There's a dissent by Justice Scalia who says the court concludes that a state may strip a mentally ill defendant of the right to represent himself when that would be fairer. In my view, the Constitution does not permit a state to substitute its own perception of fairness for the defendant's right to make his case before the jury, a specific right long understood as essential to a fair trial. And it's very interesting. I write about, and those of you who, maybe if any of you have ever read any of my work before, I write both in the civil and the criminal context. I write about saneism a lot. The way we treat people with mental disabilities, like racism, sexism, homophobia, we stereotype them, we de-individualize them, we sloth them. And to a great extent, Scalia seems to be saying it's sanest, he never uses that word, of course, to treat the defendant in words this way. He should be allowed, if he wants to do this on his own, to do it. So what are some points to think about in Edwards? Well, one, the court goes out of its way to say it's considering matters it didn't consider in Godinez, which is true, because Godinez didn't want to stand trial. Godinez wanted to plead guilty. But it's clear to me that Edwards does modify and limit Godinez, because Godinez said the only question you have to answer is the minimalist question that's in Dusky. You don't have to go beyond that. In doing so, it implicitly and maybe even quasi-explicitly rejects the unitary standard that Godinez had established for all aspects of the criminal trial. It explicitly, did I skip one there? I did, I'm sorry. It explicitly recognizes that mental illness is not an all or nothing dyadic concept, as many trial judges like to think it is. And that's endorsed by trial judges and endorsed by jurors. Hear what it's doing without saying it, sub silentio, as lawyers like to say. It concedes the correctness of Justice Blackmun's dissent about basketball and violins in Godinez. You can be competent for one purpose and not for another. And in fact, it's interesting, going off script here, in civil cases, we've known that forever. We've always known that competence to consent to an adoption is different than competence to sign a contract or competence to enter into a will or buy property. Lauren Roth back in the 70s said, searching for a unitary test of competence is like searching for a holy grail. We've always, and he was a psychiatrist, we've always known that. Thomas says in Godinez it's all the same. And finally here in Edwards, the court is recognizing that Thomas was wrong. It's focused on dignity and the perceptions of justice and procedural justice, I think, are the Supreme Court's first implicit endorsement of the important principles of therapeutic jurisprudence in a criminal procedure context. I do a lot of writing about therapeutic jurisprudence. I do a lot of thinking about it. I think it's very important that lawyers representing defendants with mental disabilities know about this. I've written an article, a freestanding article, about conversations from a therapeutic jurisprudence perspective that lawyers need to have with clients who are potentially incompetent to stand trial or pleading insanity. I think something everybody should know about. But Edwards, again, without ever stating it, really gives some gravitas to the therapeutic jurisprudence perspective. So I think it's pretty clear that Edwards is going to have an impact, a major impact on this area of the law. But it's still too early to determine to what extent other lower court judges are going to say, yeah, Godinez really has been modified or implicitly overruled in future cases. We do not know that yet. What about after Edwards? At what point can a trial judge override a putatively mentally ill criminal defendant's desires to self-represent? Well, the New Jersey Supreme Court, the New Jersey Appellate Division, a court that I appeared before many times, drew this dividing line very, very clearly in a case called State versus McNeil 1 year after Edwards. We are satisfied, says the New Jersey Appellate Court in McNeil, that a trial judge in New Jersey may, consistent with Edwards and our Constitution, deny a defendant the right of self-representation when the record sustains a finding made for specific reasons that a mentally ill defendant is competent to stand trial but cannot knowingly and intelligently waive his right to counsel without being deprived of a fair trial. We recognize that federal competency standards may not be as protective as New Jersey's, but we see no dramatic or substantive differences for purposes of Edwards. We urge that a defendant must be mentally ill and not merely difficult to handle or disruptive to be deprived of the right of self-representation. My final question: what is going to be the role of standby counsel in a pro se case of a defendant with questionable competence? And I went to Westlaw and Lexis, and I used every possible combination of words and connectors. I have not found a single case on this. And, man, it's been 7 years, and this completely stuns me. So if any of you know of any cases, let me know, because I sure don't. But I think this is something that's going to come up. What is standby counsel going to do? Because I believe standby counsel is going to be appointed more in cases where a person doesn't quite get up to Edwards' level, but the court still feels there's something going on in this case. As I said, I've been standby counsel, and it's been the worst experience of my lawyering life. I don't know, maybe some of you have had better experiences, I hope. Okay, before we move on to the next and final part, are there any questions now? Nothing? Okay.
Actually, I'm sorry.
We do. Okay, good.
Dr. Perlin said there is abundant evidence that experts cannot be duped by those that would fake in a competency to stand trial exam. Can he provide some specific citations to the psychological literature in support of his position?
I can do that, but I can't do it sitting here at this computer. I've written about this frequently. If you want to send me an email, two of my many email addresses are up there. I will be glad to send it to you. The easiest thing to do is if your office has Westlaw or Lexis access, just look up author Perlin and feigning, faking, and I think some of them will be there. Certainly, again, I've sung the song before. In my treatise, I have a long section about this, but the percentage of cases that are successfully faked are very, very low. Here's something interesting, and I think it's on point if we're talking about mentally disabled defendants. In reality, defendants frequently fake, quote, normalcy. They don't want to be seen as mentally disabled. This comes up often in the death penalty case. I've done a lot of work in the death penalty. There's a famous article by a psychiatrist named Dorothy Otnell Lewis, who did work in Chicago. And this was all trying to determine which defendants might be, quote, then was mentally retarded. Now it's intellectually disabled, and thus not be able to be executed. And the defense would tell her, I ain't no retard. Their whole sense of being egocentric, being comfortable with themselves, they rejected the retardation label, even though it would have been the one thing that might have saved their life. And there's a lot that's been written about that, and I suggest you look at that I know you can find with me on Westlaw. Send me an email. I'll be glad to answer your question. Okay. All right, so anything else? Okay, so moving ahead. All right. I had said at the beginning there are many other questions of criminal competency that have been the topic of dozens of court decisions, but they are bereft of scholarly or clinical or practitioner-based analysis. And when I started doing work about this area one of the articles of mine, I wrote an article just about this called Beyond Dusky and Something Else. It's in behavioral sciences and the law, and it's at the very end of these. It's in the bibliography. I was so stunned to see that virtually none of the cases in this area cite any of the other cases in the area. It's almost like that each courtroom was an N of one. And I analogize this somewhere. I'm a big baseball fan, you know. If somebody was traded from the American League to the National League, all the statistics in the American League would have disappeared. Same kind of thing. You know, he's in this league now, that's all that matters. A judge in Georgia wouldn't look at a case from Colorado. A judge in North Dakota wouldn't look at a case from Tennessee. All across the board in these. What I think is very, very important is to identify and categorize these decisions and then speculate as to why so little attention has been paid and why that lack of attention is seriously problematic. One of the reasons it's problematic is we ignore it. And one of the issues is, I believe, that an awful lot of defendants with serious mental disabilities waive rights without having any idea what it is they are waiving or what the consequences of that waiver is. So again, I think this is something that we need to keep in mind. Recall I mentioned a few moments ago, the concurrence by Justice Kennedy in Godinez saying that it involved that the due process clause doesn't mandate different standards made during the criminal proceedings. He never defines criminal proceedings. But this immediately followed his interpretation of the universality of the Dusky standard in other competency cases. That standard is applicable from the time of arraignment through the return of a verdict. So even there's lots of stuff you're leaving out. Nobody has written seriously. I've alluded to it a couple of times, and it's in that article I just mentioned, Behavioral Sciences and Law. But no one has ever done a full-bore study of Kennedy's concurrence and how it fits or doesn't fit with other interpretations of, quote, what does the criminal case mean? What about these other stages of the criminal process? And my bonus question, what impact, if any, will Edwards have on these developments? Almost all of the cases I'm going to be talking to you about are pre-Edwards cases. And it's not clear at all to me whether Edwards is going to have an impact on them. But it should. It should not simply because it modifies Godinez, but because of its talk about dignity, because of its consideration of procedural justice, because of its kind of embracement, without saying it, of therapeutic jurisprudence. Edwards really moves us in a very, very different way in the whole criminal justice arena. And I believe that Edwards, if we, that's the we of us who represent criminal defendants, are clever, if we are righteous about this, we're going to find ways of using Edwards in these cases that no one has ever thought of before. So I'm passing that one off along to you. So what are some of the issues to consider? Well, let's start out with search and seizure, because that's certainly pre-arraignment. The courts are split on the issue of consent to a search. I will say, I don't know how many of you are listening. Colette told me yesterday you had over 100 registrants. But out of the 100 of you, over 50 have represented a defendant with a potential MAP Fourth Amendment issue as to whether or not the guy consented, in which there might have been an issue as to whether or not the defendant knew what consent really meant under those circumstances. The courts are split. It's going to be boring. I'm going to be saying the courts are split a lot over the next half hour or so. In one case, a federal district court, this is Ocampo from the Eastern District of New York, said that mental competency is relevant to any inquiry in determining voluntariness of consent. On the other hand, Flannery, a Fourth Circuit case from '89, rejects the defendant's argument on the basis the defendant cited no authority for the proposition that such incompetency renders consent to the search invalid. That sentence would absolutely put a tremor in my heart. Does that mean counsel didn't do a good job? Does that mean there was no such case ever decided in the Fourth Circuit? Or what? Who knows? But the point is, we now know, and certainly the lawyer in Flannery should have known about Ocampo, since by 1989 Lexis and Westlaw existed and they could have found it. I think if you've got a client and there's an issue with a search, I think it's really important to think about whether or not the search is consensual may be something you need to raise if you have a MAP type hearing. Another case, not directly on point, but I think of some significance here, the Eighth Circuit, again, post-Godinez, pre-Edwards, and this is the case, it's not up on the board, of Lacey versus City of Bolivar, rules that a federal officer's placing a defendant, this is a seizure, not a search, on a 96-hour psychiatric hold was reasonable for Fourth Amendment purposes because the defendant had threatened suicide, was depressed, and was at risk to himself or others. I tell you about Lacey simply because it applies competency issues to seizure cases as opposed simply to search cases. What about lineups? I've only found one case, a case called Harris, saying that an incompetent suspect could be required to participate in a pre-arraignment lineup. I'm not sure if you will ever win that case because you don't do anything in a lineup, you stand there. But it's something that you should know about in case you have a lineup case before you. What about a preliminary hearing? Lots and lots and lots of cases in California involving preliminary hearings. And I saw some governor of some state, I only know this because it was on Facebook, wants to abolish indictment in his state and bring back preliminary hearings. Good luck with that, but it's something that people are going to be talking about. And Duncan, the case that I have up there, is the typical case that if an information is dismissed due to, and information is sort of like an indictment, due to the defendant's incompetency at the preliminary hearing stage, the defendant is entitled to another preliminary hearing once competence is restored. So in other words, the courts in California are taking this fairly seriously. What about trial process? Now, at this point, we are past the arraignment. The person has already been arraigned. He's at trial. So according to the concurrence in Godinez, Godinez matters. Whereas a concurrence said, for everything I've talked about for the last several minutes, Godinez doesn't matter. But what you have to think about is, is this case more like Godinez, is this situation, this fact pattern, is it more like Godinez or is it more like Edwards? And let's think first about jury waivers. The Ninth Circuit has said, again, there's a split, hello. The Ninth Circuit has said that a waiver should not have been accepted without further inquiry as to a defendant's mental state. In other words, whether or not the defendant can ask for a bench trial. California's appellate courts, on the other hand, have said that a defendant's due process rights are not violated when the jury selection proceeded and no finding of incompetency had ever been made. The Southern District of New York agrees with that in a case called Brown versus Doe. So it's kind of all over the place, again, as it is in many other areas here. What about evidentiary questions? Impact of a defendant's incompetence on the admissibility into evidence of letters he wrote at a time when he had been found incompetent to stand trial. Virginia Appellate Court, in a case called Jones v. Commonwealth on your board, says it's not error. The fact that he had been found to be incompetent when he wrote these letters does not preclude their admission into evidence. On the other hand, there's always another hand. Williams versus State in Indiana case said it's reversible error to use deposition testimony of a victim in a criminal case that was taken when the defendant was incompetent, presumably because he could not assist his lawyer in the deposition and asking the right questions on cross-examination. Makes total sense to me. The other case, the Virginia case, makes no sense to me at all. if a person is so incompetent as to not be able to stand trial, it's a really, in real life, a very, very high burden. What value of any sort can we give to testimony, to the contents of those letters? I suppose it's okay to say the letters were written, but I don't think it's okay to say what they had to say. What about the question of statements to the media, of finding the defendant was incompetent to stand trial? This is a case called Mann out of Maryland. Compelled the conclusion he was incompetent to waive other rights relating to the prosecution, speaking publicly to the media about the alleged crime. This case doesn't come up a lot. I'm only raising it for you because I want you to think about all the different areas in which these kinds of cases may come up. What about competency of jurors? I think that's a very interesting question. Arizona case, 1990. During deliberation, one of the jurors said to the other jurors, "I have a reactive psychosis." And that came out after the trial. Court said, not an error requiring reversal of a conviction. And my answer is, who knows? The fact that a juror had a psychosis, to me, does not mean in and of itself that he can't be a juror. But what impact did that psychosis have on his sitting on the case, on his processing the information? It seems to me in cases like this, defense lawyers really have to go out of their way to ask for hearings. I know judges very often don't want to inquire into anything about the jury after the conviction is done. But I think in a case of this sort, it's really, really important to try to figure out what was the colloquy between this juror and the other jurors in an effort to determine what impact this might have had on the rest of the case. The most interesting area here is the question of competency of witnesses. And I don't think Godinez applies to this because witnesses are not the defendant. And there's a couple of lead cases. Sinclair versus Wainwright, which is up on the board from the 11th Circuit from 1987, but relying extensively on Schuler versus Wainwright from the 5th Circuit, which is basically the same circuit then, from 1974. And I think, and this comes up in so many cases, certainly anyone who's been a public defender for more than a few weeks, or has done criminal trials for more than a few weeks, has had witnesses on the stand, both that you've called and both that have been called against you, in which you have a question as to that witness's mental competence. Well, this is something to think about, and I think some of this case is very misguided, but it's something to talk about. It says a person with a mental disability may be allowed to testify if he is able to comprehend the obligation of an oath and give a correct account of matters he has seen or heard. Okay, fine. Although, again, what does being a person with a mental disability mean? Does that mean anybody who comes within a classification in DSM-4 or DSM-5? I mean, think about all of the people who are, called colloquially the worried well, people who go and seek therapy for a whole variety of anxiety, depression, family relation issues. Do they have a mental disability? Well, their therapist probably has said they do, so the therapist can get paid by the insurance company. I don't think Schuler and Sinclair are talking about that person. But when you read that line, this really makes you question what the limitations are on such a person's right to testify. My question is, to what extent does the Americans with Disabilities Act speak to this? Again, not out loud, but does it speak to it? And here's something I've gone 2.5 hours without mentioning, I'm going to talk about now. What about international human rights law? Think about the Convention on the Rights of Persons with Disabilities, which I've been very good at not mentioning it all today because I could go on that forever. If you have any questions, please ask them to me because we're going to have some time at the end. But the CRPD clearly would reject any kind of a policy or a theory that says the fact that a person has a disability can stop them from testifying. And what do we do about that? So the court says that first, but it goes on in the next sentence. And this is clearly, this is clearly a key to Sinclair and something that concerns me. If a patient in a mental institution is offered as a witness an opposing party may challenge competency, whereupon it becomes a duty of the court to make such an examination as will satisfy the court of the competency of the proposed witness. We know the fact that somebody is in an institution does not, in and of itself, make him incompetent to testify. One does not. There is a presumption of competence. There must be an independent finding of civil incompetence to stop somebody from testifying. Most state constitutions say this. Every court that has ever decided this case in a civil side has said this. The fact of, one cannot presume incompetency from the fact of institutionalization. But Sinclair here, being cited in Schuler, says that being institutionalized raises a presumption, a rebuttable presumption, that the person is incompetent to testify. I think that's dead wrong. And I think that's something every lawyer in the room needs to think about as we are talking about this. And the court says, if this challenge testimony is crucial or significant, failure to conduct an appropriate competency hearing implicates due process concerns of fundamental fairness. Well, I agree with that if, in fact, there is some kind of evidence that the witness is, in fact, incompetent. But I don't believe that whether one is in an institution, was in an institution, or never, in and of itself is relevant. Perhaps their psychiatric record that might have led them to it would be relevant, but institutionalization per se, I don't believe is. And I think that's something that anybody working in this area really needs to think about. And again, I say here, I think that that assertion that you can challenge someone solely because of that, I think it's seriously flawed. And I really counsel you not to follow that. Incompetency cannot be presumed, again, as I said, because of mental illness or because of institutionalization. There is no necessary relationship between mental illness and incompetency that renders mentally ill persons unable to provide informed consent to medical treatment. That's where this all comes out. No reason that should be any different than this. There is no subsequent case law that question this aspect of Sinclair. Sinclair was from 87, I think. Schuler was from the 70s. It's been a long time. These are circuit court cases. No one has ever challenged these. And again, this involves a witness testifying against your client, but this is utterly bilateral. That was the fact in these cases. This could also be used to challenge a witness who is going to testify on behalf of your client. So I think the issues raised in Sinclair and Schuler are extraordinarily important ones and are ones that lawyers should think about because, again, if you've been doing criminal trials, you know that this is going to be an issue that you need to consider. Okay. Beyond that, what else? What about the impact of incompetency on an ability to enter an insanity plea? And I know this from my own practice, and colleagues of mine from all over have told me. Most insanity defense cases, as you know, are not contested. I told you earlier, I've been getting these phone calls from the press about the Batman killer, Holmes in Colorado. And that, of course, is a media circus, and you've got, really, top-notch psychiatrists on both sides. Most cases are not like that. Most insanity cases are walkthroughs. 90% of all insanity cases are stipulated on the papers. We know that, and I've got all sorts of valid and reliable research on that. And I can point you to that later if anyone has a question. It's only 10% of cases in which there's a difference. The battle of the experts just doesn't happen. So in cases that are mostly the 90%, judges are very eager to get rid of it. And if your client is going to plead insanity and he's incompetent, the judge is going to try to push you to plead him not guilty by reason of insanity while he's incompetent. The Cool Broth case from Colorado from 1988, still the lead case says, due process prohibits this. You cannot determine sanity until such time as a defendant is restored to competency. So I think that's something you really, really need to keep in mind. On the question of GBMI, same thing. Harris, Michigan, 1990, GBMI conviction would be invalid where the defendant's competence had not been reevaluated before trial. So again, there's going to be pressure from the court in these cases. I've seen it many, many times. Be strong and just say no, and you will win if this goes to appeals. What about after trial? And again, we know from the Kennedy-Scalia dissent, this is not part of what they thought Godinez included. Defendant has a right to be competent at a motion for a new trial. That's pretty much, something shouldn't surprise anybody. What's most interesting, I think, is sentencing. We know that a court may not sentence an incompetent defendant, and here I've given you 3 different cases to look at. There are many, many more than this. What about the case, and this happens more than rarely, of a defendant who becomes incompetent between the time of the guilty verdict and the time of the sentence? Most state statutes say that the same test to be employed is the one that's to be used to determine if he is competent to stand trial. So if you've been competent to stand trial and you lose your competency, and that happens. I mean, some defendants, some are obviously out on bail pending a sentence, but most are in jail, and sometimes that lingers on and on and on, and the pressures of being in jail, knowing you're going to prison, may exacerbate pre-existing mental illnesses, and it's not surprising at all that a certain percentage of these defendants become incompetent. Well, the court says you use the same test as you use to determine competency. So that's Dusky, or if a state wants to, a state can have a more searching test. I didn't talk about this, but in New Jersey, where I practiced, the test for competency to stand trial was much more searching than Dusky. There were about 6 or 7 different criteria that the court had to be sure of before it could find that the defendant was competent to stand trial. So this is not necessarily just Dusky. It's Dusky or a state statute or state constitutional decision that gives a defendant more rights. And why is this important? Because there's an emphasis here, and there's a case called Wochtowich, which I probably pronounced wrong, from the Second Circuit back in '77. There's an emphasis on the defendant's capacity to tell the attorney about factors that might mitigate the sentence, might refute aggravators that were raised by the prosecution, as well as an understanding of his punishment. Those are separate issues. Can the defendant, 1, consult with counsel and tell counsel stuff that either mitigates or rebuts aggravation? And number 2, does he understand how he's being punished? That latter issue comes into play. Remember, I said at the beginning, I'm not talking about competency to be executed. Well, that's all over the books on that. Does the defendant understand why he's being executed? But that question of comprehension of what's going on is much, much more than simply a death penalty issue. I should also tell you, one of the things that I'm very interested in is the whole question of the federal sentencing guidelines and defendants with mental disabilities. I've written about that, and I'm doing some more work on it now on one of the most interesting things that's happened. This is kind of a good shout out to all of you, even though it's not directly on point, but I think it sort of is. DSM-5, the Diagnostic and Statistical Manual of Psychiatrists, greatly expands the definition of PTSD, post-traumatic stress disorder. And this is especially important now because so many veterans coming back from Iraq and Afghanistan are in their prime crime-committing years. Question: if DSM-5 expands PTSD in this cohort of defendants with mental disabilities, how does that play out under the guidelines? To what extent do the guidelines that allow for a downward departure in some cases involving mental disabilities, to what extent should lawyers representing these defendants start thinking about that? None of the literature about that, about the PTSD issue, has gone to what I'm talking about here. a defendant's capacity to be sentenced. But I believe that in the coming months, years, this is going to explode because we have before us more and more criminal defendants with this condition, and judges are going to have to sort of think about whether or not it's going to have an impact on the sentences they get. But what about if the defendants, before they're sentenced, begin to deteriorate in the jail? To what extent will judges look at that in making their dusky decision? Trust me, no one has ever written a word about this. I'm not sure many people have ever thought about this, but I think it is extraordinarily, extraordinarily important. Okay, what about resentencing? And there's no cases. Elizabeth Ford, who's a friend of mine, wrote about this several years ago in the Journal of the American Academy of Psychiatry and Law. What are the implications of all these doctrines on resentencing of prisoners who may have been competent when they were originally sentenced, but whose mental states have deteriorated while they're imprisoned? Maybe being in a prison becomes much more dangerous for them. Maybe they should be resentenced and maybe then go to a psychiatric hospital or some other alternative. Dr. Ford writes about this, and she wrote about it in the context of the Rockefeller Drug Acts in New York. I recommend that article to you. Again, no litigation yet, but it's something I believe that public defenders should have on their mind. Okay. It goes on and on and on. What about probation violations? Courts are split on this, again, whether or not a competency hearing should be conducted prior to a probation violation hearing. And you've got State versus Lockwood, a Vermont case from '93, saying there is no requirement for a hearing. With State versus Singleton, South Carolina '96, the court abused its discretion in not ordering a competency evaluation. Frankly, cases like Lockwood mystify me. A probation violation hearing, the probationer has to be able to consult with his lawyer, has to be able to understand the charges against him. Their probation is being revoked. He's going to jail. He may have a story to tell. Maybe he missed the probation appointment because it was his mother's funeral. That's a real story. Who knows? Well, the point is, if he can't communicate with counsel, if he can't rationally assist his counsel in presenting a defense, in presenting an argument as to why he should not be violated, then I don't see how that differs at all from any of the dusky second-generation cases. If he's not competent to stand trial for the first charge, the charge that got him there in the first place, I don't see how he can be found competent to stand trial on the probation violation. Now, what's interesting is that in terms of parole hearings, courts usually find that before a parole hearing can take place, which of course is generally done in a prison by the parole authorities, which is not even a court, courts generally find that the court has to have a separate hearing to determine his competency to participate. Why most of the cases go this way with parole and not with probation? Search me. I don't know the answer. The Qualls case, which is up on the board from Ohio in '88, says that the issue of competency to participate may be raised by the court or the defendant. The decision as to whether or not to hold a hearing is vested in the court's discretion. The Newcomb case, or I guess the Metz case in New York, says unless there's statutory authority to the contrary, fundamental fairness mandates a consideration of the parolee's mental competency. Again, if Metz gets that, why did the Vermont court not get it in the case of a probationer? I don't know the answer. And one of the reasons I don't know the answer, by the way, is that the courts don't explain their decisions. If there were long theoretical explanations, as there was in Sinclair and Schuler, the competency of a witness we talked about, it would be on the PowerPoint slide. We'd be talking about it. But courts decide these cases, and this is actually very, very important. Courts decide these cases cursorily, one or two lines, And part of that, I go back to my C major court of life, is saneism. This cohort population isn't seen as being terribly important. They have fewer rights than others. So the courts find no reasons to go out of their way to write more expansive hearings. What about conditional release? Court says, and these cases here at this juncture, most of the cases fine for the defendants. Jenkins, Connecticut, 08, the court has to hold a separate hearing to determine his competency to participate in a PCR post-conviction habeas corpus hearing. Court says it's generally the same as competency to stand trial. So again, when we go back to the probation case, and probation is important. There are I don't know the number, probably most of you do, as to the percentage of people who are in prison because of probation violations. I read something relatively recently that in Wisconsin there are more people there for probation violations than any other crime, which is pretty frightening. So why in some states that cohort of defendants don't have the right to a competency hearing, whereas they do in parole cases, in PCR cases, in conditional release cases, I simply don't know. Interesting, and I actually left a slide out on this, and I apologize. On the question of competency in appeals, Supreme Court decided a case that almost no one's ever heard of called Martinez versus Superior Court about 15 years ago, and said competency doesn't matter in appeals because appeals are strictly questions of law. What do you think? They're mostly questions of law, but certainly all the years I did criminal appeals, it was important to me to look at the record and see how the facts were put in, and just maybe my client would have something to say about some testimony that I could have missed because my client knows a lot more about it than I do. But there have been, no one knows about Martinez, never written about, never discussed, but I think it's very important. So what are these other, we're just about finished now, miscellaneous procedural matters. Extradition, which has always been one of my favorite areas of the law. Defendant has to be competent to participate in an extradition proceeding. And the last thing I'm talking about is participation in an SVPA proceeding. And the court in Wisconsin in Smith says that a defendant has the same right to be competent as in any other criminal proceeding. Well, this is all well and good, but I have to caution you with something. Again, I don't know which of you, 20 states have SVPA, Sexually Violent Predator Act statutes, 30 don't. I don't know which of you are from those 20 states. But in many of those states, there is no right to counsel at an SVPA proceeding. In most states, people who are found to be sexually violent predators are institutionalized for life. It's life imprisonment. And yet, there is no general right to counsel. A colleague of mine and I wrote an article about this, which was published actually this week on this issue. And it's not in the bibliography, but I'm happy to, if anybody's interested, send me an email. I'll send it to you. It should be available any day now on Westlaw or Lexis. It's called Far From This Turbulent Place is the beginning of the article title. That's a Dylan lyric. But I was just amazed when Heather and I, my colleague, did the research, how many states say there is no right to counsel, even though somebody can be locked up in maximum security for the rest of their life. At least Smith says you have a right to be competent before that happens. So, what do we have for the future? Well, it seems to me that questions of competency are going to grow in importance in the coming years. And I think that as trial judges begin to figure out Edwards, and they have not yet, not by a long shot. There's a lot of post-Edwards cases, as I've told you, but courts haven't really taken it that seriously, and they have only looked in Edwards at the exact issue that was before the court in Edwards. A person competent to stand trial, competent to plead guilty, but not competent to represent himself at a trial. And that's the holding of Edwards. But when you read the theory behind Edwards, the ideas that procedural justice matters, this therapeutic jurisprudence approach, looking at dignity, that line about that it's not ennobling. When you think about all of that together, think about some of the clients that you've represented in which you may have felt that there's a trial going on, but something's happening, and it's not real. When Colin Ferguson, the guy who killed all those people on the Long Island Railroad, was convicted, he was sentenced to about 500 years in prison, which most people were very happy with. But they talked to the victims' families, and they said, we were left with an empty feeling. This wasn't a real trial. Because he was so, quote, crazy, end quote, that it didn't feel, and he was representing himself, that it did not feel like a true trial had taken place. That's very, very sobering. And I think it's something, we should all keep in mind. It's not clear at this point as to what impact Edwards is going to have on cases, on subsequent cases that are like cases that were decided when Godinez's unitary standard was settled law. In other words, let's say a case that was decided in these last categories that I've been talking about for the last half hour. Let's say that a case was decided after 1993, and the court said, see Godinez standard, there's all one standard. To what extent are state Supreme Courts going to say, oh no, we can look at that again because Edwards modifies Godinez? Again, even though Edwards went so far out of its way to say it's not overruling Godinez, to what extent will judges relook at all of these issues in a post-Edwards world? It still hasn't happened. I expect it will over future years. Diane, do we have any other questions? Good.
Yes.
Because that's basically, it's it from here. Okay. I now have, by the way, on next about 1, 2, 3 slides of bibliography, and you're welcome to download or order any of these. Go on.
Some attorneys may be hesitant to bring up issues of competency with their clients for fear of injuring the attorney-client relationship, especially when dealing with a client who does not perceive himself to be ill or otherwise incompetent.
Right.
Do you have any tips for how attorneys can talk to their clients about the need for a competency evaluation?
Give me 1 second here. Look at number 3 on bibliography 2. Too stubborn to ever be governed by enforced insanity. Some therapeutic jurisprudence dilemmas in the representation of criminal defendants in incompetency and insanity cases. That's where I talk about this. This requires tremendous sensitivity on the part of the lawyer. And when I write about the article that I mentioned earlier that's in press now about PTSD, I try to offer some dialogues that lawyers need to talk to their clients about. It is not easy. And there have been times when I have talked to my client with my expert witness holding my hand. I mean, I've said, okay, let's talk to him together, because I'm not a psychiatrist, I'm not a psychologist, but I know something about them, but that's still not my background, that's still not what I do. And having an expert witness with me has given me a tremendous amount of traction. There are so many ways of saying the same thing to people that come out so differently in terms of tone. And you can say to somebody, I'm your lawyer, I'm representing you, I want to do the best I can, but I got to tell you, some of the things that we're talking about don't compute to me. They're just not making sense. And I think it would really be a good idea if we could have somebody, have a professional come in and talk to us. And then the guy would say, I'm not going to no expletive deleted shrink, right? That's going to come up there. Say, well, nobody's going to shrink you. Nobody's going to try to change your behavior, but it's going to help me represent you. I am your lawyer. I'm the person on your side, sitting with you at counsel table. I want to do the very, very best job I can. And I believe, and I've been doing this for X years, I believe I can do a far better job if you talk to this person I'm recommending, who I know well, who has done a great job for other defendants in the past. If you talk to him, he talks with me or she, and then we can come up with a better strategy. And I said it, I'm using tone. That's how I said it. In a very conversational, help me get better way. I want to do the best that I can for you. Most people get that. If somebody doesn't get that, then there's some real, very serious problems, and that just makes it a little bit easier in some ways. But the marginal person, I have found, generally understands that. One of the most interesting cases I was ever involved in was not it's not an incompetency case at all, but I'm going to answer it because it tells you exactly what not to do. And I wound up representing this guy at a later stage of the case. It was named State versus Khan. It was in New Jersey, Khan. Khan was a relatively small man, 5'4", 5'5", 130, 140, who was a landlord of a building, and he had had trouble with this one tenant who was a big guy, 6'3", 230, 240, and the guy was threatening him. The guy was very abusive to him. One day, Khan goes into the building, and this other guy is on a ladder changing a bulb or something, and Khan says to him, "What are you doing?" And this guy had harassed him in the past, had threatened him, may have physically assaulted him. And the guy points something at him. And Khan said, "I thought it was a gun." Khan had his own gun. Khan shoots the guy. It wasn't a gun. The guy was in construction works. It was kind of one of these triangular things with a handle that you hold like 5 or 6 keys on, but in the dark, different angle. I saw it. Easily could have looked like a gun. You have a real self-defense case there. A smaller person, someone who has harassed him, somebody who is threatening him and points something at him that looks to an objective person like a gun. It's a self-defense case. The lawyer goes to the jail to talk to Khan and, says, "Okay, this seems to me, you have a good shot at self-defense." And Khan says, "Great, but there's one other thing." I say that with a smile because anytime anybody says there's one other thing, you kind of hold. "What is it?" He said, "Can you do something about the fluoride in the water?" And the investigator says, "What are you talking about?" He says, "Well, there's a conspiracy in Serbo-Croatia that's fluoridating our water. And what it's doing is it's changing our politics." This is before, by the way, we knew about, this is before Yugoslavia split up, so Serbia and Croatia were not in anybody's mind. The investigator goes back and says to the lawyer, "This guy's out of his mind. We're pleading him insanity." And the Khan says, "I'm not insane. These are my politics. I shot him because I thought he was coming after me." And we wound up being successful finally as to whether or not a person had a right to not plead the insanity. A competent defendant had the right not to not plead the insanity defense. That lawyer did everything wrong. That lawyer imposed his own view. He took one piece of information, and by doing so, scuttled the defendant's legitimate defense. What do you do in these cases? You talk to your client as you would talk to anybody else and try to get him or her to see that you are trying to help them. Now, someone asked me the question before, the question I said was so excellent, about what happens if by doing this evaluation the person winds up in Hotel California. What then? I think the whole question here is, there was 2 or 3 questions. One, how serious is the charge? Would it be a bailable charge if the guy was not involved in the mental health system? And what is the delay in your facility for doing these kinds of hearings? And there are some facilities in some places where they are done very, very quickly. The state of Washington, I'm not sure, was this a Washington person who said it?
I think so.
There was a case recently, I gave you that information, I'm thinking, Michael, there's something wrong here. There was a case in Washington recently in which a court ordered that evaluations be done within a specific period of time. I don't know if it's been reported, if it's on Westlaw or Alexis, or whether it's just a court order. Colette?
It's Washington State Judge Marcia Heckman.
Okay, good. The officials at NACDL know this case, so you can contact them and they can give you the site on it. So if you're in Washington, you're in great shape. If you're not on this issue, if you're not in Washington, take that case, download it, and file it yourself in your own jurisdiction. I hope that helps, that answer. It went all around the park, but I think I might have gotten to a few things. Other questions?
We have one more question in the queue right now. Although questions of mental illness and competency are not necessarily one and the same, it can be difficult for attorneys with little or no training in mental illness and or competency issues to identify whether mental illness may also be causing incompetency. Should a cautious attorney ask for a competency evaluation anytime his client has a history of severe persistent mental illness? If not, do you have any tips for attorneys to help identify when competency is an issue?
Okay. Most incompetency cases involve people who are severely mentally ill or people with significant intellectual disabilities. Having said that, a person can be severely mentally ill and still be competent. My tips are this. When you talk to your person, think about the responses, both as someone, how somebody in the free world would respond, and number two, how other inmates of the same jail would respond. Is this really off track or not? I think it's very, very important that all lawyers doing criminal defense work get some kind of training in this area. I have gone to various places. Last year, maybe it was 2 years ago now, I went to Georgia. No, it was last summer. I went to Georgia, and the Georgia Association of Criminal Defense Lawyers brought me in to do a 2-day BOP till you drop seminar on all of these issues. And I was fortunate enough to speak to just about every public defender in the state. And I think, as opposed to this, 3-hour program, we did about 14 hours. I think that was a good start. I'm happy to do those. There's other lawyers who can do those. There are in many places CLE programs that do these kinds of things. I know of CE programs that are run by forensic psychologists that do them. I'm hoping NACDL starts running more of these kinds of programs. Colette is smiling at me, because I think this is really, really important. Here's a piece that I should have said before. We all too often are seduced by physical depictions. Does he look crazy or not? A, that we can define who is and who isn't by how they look. But two, that very often, just by looking at physical issues, at visual issues, we miss so much. Judges have said very tellingly, look, he looks as normal as you or me. What is the judge saying? The judge is saying, I'm looking at this guy, and he doesn't look like the really crazy guy I saw walking down the street talking to himself, muttering. Well, that's wrong. That doesn't tell you anything about it. One of the things that I think is very important is to have, even, forget about the incompetency to stand trial evaluation, is to be able to bring in an expert witness and talk to your client. And I always wanted to be with my expert witnesses, and the best expert witnesses I ever used wanted me to be in the room with them when they talked, because I think, you're the lawyer, you've talked to this guy a lot, and you're going to see, A, is he talking to this witness this expert differently than he talks to you? Are you picking up on things? Is he saying something that you know is a rabbit hole? You've got to go and talk to that guy in Montclair who knows all about the gay bar, right? It has nothing at all to do with your case. But he will say that your client might say that because it's one of his sort of delusional things. Or is he simply somebody who has, didn't have a lot of school, isn't very literate, but knows what happens? He knows, I was in a fight, but the other guy hit me over the head first. And if that's the situation, which is a lot of our cases, then, the fact that he is mentally ill might not count. I always say in my mental disability law classes, this is back when The Sopranos was on TV, which is like my second or third favorite show of all time. The Wire being number one, far and away. Thank you. I'm getting applause from the people here. Well, I just saw Bloodline on Netflix, which is absolutely terrific. I do digress. Look at Tony Soprano. Tony Soprano sees Dr. Melfi all the time. He's got a major mental disorder. He's clinically depressed. He is a very, very dangerous guy, right? I mean, he orders killings, loan sharking, mob stuff. But no one's ever going to say that Tony Soprano can be civilly committed or is incompetent to stand trial or has an insanity defense. The mere fact of mental illness alone is not enough. It's got to be mental illness as it affects your relationship as the lawyer. Can he or she consult with you? Are you able to represent this person fully and adequately? Those are the questions you have to keep in memory at all times.
All right. Michael, that's the end of our questions, unless there's anything else that you want to add.
I've loved this. I hope you've enjoyed it. Again, you've got my email addresses up there. Feel free to email me. I would rather you email than call, since I am emeritus, meaning I'm retired. I'm not in the office very much, so email is a lot easier. And I'll get back to you quite soon. I'm very good on my email. I've enjoyed this. I hope you have. Thank you.
Thank you all for joining us today. If you did enjoy today's program, please consider becoming a member or attending one of NACDL's outstanding continuing legal education programs. Discounted rates are available for public defenders for both membership and conference attendance, and scholarships are also available for full-time public defenders and for private assigned counsel to attend programs as well. More information can be found online at www.nacdl.org/indigent defense.